Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to Legal Ease, the show that converts legal jargon into legal ease. If you've been following us on Twitter, as I hope that you now have practice in doing and making it a habit, you will see that the aim of tonight's show, or the topic of tonight's show, is surrounding the new arrest of Brother Moazzam Beg. If you don't know who Moazzam Beg is, we would like to remind you that Moazzam Beg was a guest on our show in December when he formed part of the delegation of cage prisoners, as they were formerly known in the UK, which is the organization that attempts to help those detained under the unlawful, or at least what some people consider to be unlawful, anti-terrorism laws of the United States of America and the United Kingdom. Now, we have in studio with us this evening a very esteemed legal mind who will be able to assist us in unpacking what it is about these anti-terrorism laws that is so confusing, how it's possible that the UK and the USA are able to exercise these laws so freely. And we'll also be talking via Skype to one of the brethren of Moazzam Beg, who is also a member of Cage UK, and his name is Brother Cerie Bullivant. But for now, we'll start with Professor Hennie Strydom. Good evening, Professor, and thank you very much for joining us on such short notice. We really appreciate your assistance.
Good evening.
Just to introduce a little bit about the professor is a professor in international law and holds the NRF chair in international law at the University of Johannesburg. NRF is the National Research Foundation. Professor, you also have many degrees and you have many publications and articles under your belt. And if you want to read those, which I suggest you do if you have any interest in international law, you can just Google the professor. But for tonight, what is it, Professor, that you actually fill up your days with right now?
Well, mainly research and the supervision of postgraduate students, sort of collaboration with foreign scholars, and also in South Africa itself. That makes up my daily task.
So the aim of the research chair, insofar as the NRF, what is its purpose really? I know it started sometime in 2007, I think it was?
Yeah, it's to expand the knowledge pool in South Africa especially, and to train and supervise a greater pool of postgraduate students, and to expand this knowledge field in South Africa.
And on international level, insofar as international law is concerned, how does South Africa fare? I mean, are we at an equal footing, or are we on a decent playing field, so to speak, with the rest of the world?
You must understand that since 1994, we've become part of the world again, so to speak. We have signed, ratified a great number of treaties of all kinds. We have participated actively in the United Nations and also in the African Union.
Yes.
And yeah, I think South Africa's voice is sort of reckoned in many parts of the world, and we play an active role in these fora.
Yeah, we've only had 20 years to do so. I mean, a lot of these other guys have been doing it a lot of these other countries have been doing it for many more years. So
that is correct. So we still have a way to go.
So again, then that's obviously the reason for this research chair. Professor, so we talk of ratification of these treaties and so forth, and we're going to get to the real nuts and bolts of the topic of the show just now. But just for our viewers to understand, and bear in mind we have lay people sitting at home, when a treaty is ratified, you've got, if I understand, you've got member states and then you've got signatory states, right? So can you just explain for us, there's a convention or a treaty between countries, or the UN tells all the countries, we want you all to come and sign this treaty. It then becomes ratified. What is the process, and what is the implication of signing a treaty?
Yeah, those are technical terms. So basically, when a state decides to ratify a treaty, it becomes a full member of that treaty, and it's bound by its terms and conditions. But there is a process that states follow. Sometimes they will sign but not ratify, because they need time to consider the consequences of that treaty in their domestic legal systems.
Okay.
So signing is a sort of a preliminary step. It gives the intention also to the other parties that in the near future, the state will then ratify and formally bind itself in terms of the treaty. That is the one part of the process. We must also understand that in terms of national law, and in many cases in terms of the national constitution, there is a process to be followed, considering the different steps to be taken to become a member of a treaty.
Okay, so I'm sure then it will work. It'll basically boil down to whether or not that state that becomes a member of the treaty will be able to comply with that law. That must be
Correct.
one of the
Yeah.
major factors, I'm assuming.
Correct, but one of the significant steps in this whole process is that once the state has ratified, it is bound in terms of the treaty on the international plane, meaning that it is bound to follow the treaty vis-a-vis the other parties to that treaty. But for that treaty to become part of national law, Parliament must legislate.
National Parliament.
National Parliament must then give domestic effect to that treaty for that treaty to become part of South African law.
So then it kind of shows a bit of complicity, so to speak, from the nation state insofar as the treaty is concerned. So let's take, for example, now this Anti-Terrorism Act. What do we know about the Anti-Terrorism Act?
Well, since 2011, September 11, the whole world has sort of reacted to that in terms of action that was taken by the Security Council and the United Nations in general, making it obligatory for states to adopt legislation at the national level for that purpose, to combat terrorism in the world. So in reaction to that, states have adopted legislation at the national level. That's the one part of the story. The other part is that many states have signed up on a great number of treaties dealing with anti-terrorism measures. And in terms of those treaties, the states were obliged to legislate at the domestic level to give effect to those treaties at the national level and to make it enforceable in your national legal system.
So, you see, and here's where it gets a little bit sort of iffy for me. And I think that when we introduce our Skype guest just now, we're going to hear a little bit more about the practical application of these legislations. Is there a should I say, a guide to these nation states who are signing these treaties of how to adopt such legislation, and more importantly, how to enforce it?
There are broad guidelines in terms of the treaties. Every treaty will spell out in this regard the measures to be taken.
Right.
So in terms of that, the treaty will contain certain broad guidelines. But what has happened since September 11, the Security Council has, in terms of its own resolutions, gave much more detailed instructions to states how to go about in adopting national laws for that purpose, and how that laws should be enforced.
So more liberal or more stringent?
It is more stringent. I think, well, there's a huge debate going on in the world nowadays to say that since September 11, the Security Council has started to legislate for states how to go about, which is a totally different trend compared to what the Security Council did in the past. I mean, the resolutions prior 9/11 were sort of loosely phrased in general terms, but since 9/11, much more detailed instructions were given to states, especially in the field of anti-terrorism measures.
So then what you're saying ultimately is, in layman's terms, those member states and the signatories to that treaty needed 9/11 to properly stamp their authority on what they wanted to do insofar as anti-terrorism was concerned. Because after that is when it really pepped up.
Correct, and you must also take into account, and the listeners and viewers as well, if you're a member of the United Nations and you've signed up on the United Nations Charter, and a resolution is taken by the Security Council in terms of Chapter 7, which deals with peace and security matters, member states are obliged to follow that Security Council resolution.
Now, if they don't, there's a breach by a member state. What is the penalty, and how is that penalty enforced?
Well, there are mechanisms within the United Nations organization to deal with that.
Okay.
There will be sort of diplomatic pressure.
Yeah.
There will be pressure from the Security Council, and all kinds of diplomatic relations will come into play in order to try and convince the state to comply with its duties.
Yes.
Because in terms of the United Nations Charter, when you sign up on the Charter as a state, you undertake to comply with your obligations in terms of the UN Charter.
Now, I mean, I've read up on the UN Charter, and I know that the ultimate enforcement or penalty, should I say, is war. Because if the state now is deliberately not coming to the party and not willing to comply and is constantly breeding, so for example, it becomes guilty of war crimes, or it becomes guilty of acts against humanity, or it becomes guilty of all those things. Is that different now, or is that...
No. That kind of sanction will only be used where there's an unlawful use of force by a state.
Okay.
Then the Security Council can collectively authorize the use of force against that state. The ultimate sanction in this instance that you have mentioned, where there's a constant non-compliance with duties in terms of the UN Charter, is expulsion from the organization.
Right, okay. Yeah. Okay. Professor, let's turn now to our Skype guest, Brother Cerie Bullivant in the UK. He is obviously from, as we mentioned, Cage UK, formerly known as Cage Prisoners in the UK. As I mentioned, if you heard my intro, Cage UK is predominantly focused on the release of detained prisoners, either at Guantanamo Bay and, as I'm sure you've had experience in, black sites around the world by the United States and the United Kingdom. Cerie, assalamu alaikum, good evening, how are you?
Wa alaikum salam wa rahmatullah. Thank you for having me on the show. I'm very well, thank you.
And thank you, Cerie, for joining us. Just a very quick background on you, Cerie. I know that you've joined Cage UK as a media officer. Where did you come from and what is your role?
I'm a filmmaker by trade, and I've been working in the arena of human rights for around the last eight or so years. In 2006, I was placed under a very, very coercive and draconian piece of British legislation called a control order. What that meant was I was placed under a list of conditions without being arrested, without being accused of a crime. I was placed under a list of conditions which pretty much amounted to house arrest. On the basis of secret evidence, which I was never allowed to see. After a 2-year legal process and having gone on the run, I was eventually cleared of all charges and all accusations. Well, there were no charges. I was eventually cleared of all accusations, and my freedom was restored to me. After that period is where I became involved with Cage. And very recently, I've taken on a full-time position with them as the media officer.
Now, I read in the article that talked of the control order that was issued, is that the judge in the Supreme Court stated that MI5 had insufficient reasonable suspicion or any evidence whatsoever to place that control over you, and that was then effectively rescinded with immediate effect.
Yes, after 2 years of fighting it through the courts, the first time that a judge actually got to see all of the evidence, the first time that the evidence was tested, that judge said that there were never any reasonable grounds to suspect that I'd been involved in terrorism. He said that if he'd have seen it after the first control order was put on, he would have quashed it immediately. So the part of the problem was that getting any legal recourse took 2 years. And this is a system that is designed to destroy your life and basically put you in legal limbo without even knowing what the accusations are against you, much less even the evidence that's being used.
Is that the so-called...
Everything is secret in the old control order system.
Yes, that's the so-called secret evidence that you refer to in the articles that you've written on the issue. Then you went on to win the award for liberty and rights. I think it was for the Young Person Award in 2011. Is that right?
Yes. With my campaigning on issues around secret evidence, I was very honoured to win the Liberty Young Person of the Year Award for my campaign work around secret evidence and illegal detention and control orders. I've since spoken numerous times at Parliament and a variety of forums and rallies and on the issue of the counter-terrorism laws within the UK and how draconian they are and how they're fundamentally repealing rights that most people would consider inalienable rights.
Cerie, if you listened while we were talking, myself and the professor, you've heard me introduce the professor, and you heard the professor deliberate a little bit on this issue of international law and anti-terrorism and so forth. We're going to turn to the professor now. We're just going to try and unpack what you've said to us. Professor, this issue of a control order, I mean, there's so many things that sound wrong with it. You're aware of a control order? It's as he says, a pretty draconian measure of English law.
Yeah, that's only one measure. I mean, since September 11, states have resorted to all kinds of measures in order to give effect to anti-terrorism legislation and to comply with Security Council resolutions. And sometimes, and in many instances, they've gone overboard in the sense that basic human rights, due process principles have been undermined. And there's a huge debate in the world today, and lots of sort of interventions by scholars, by lawyers, etc., to try and restore the balance, because the balance has been distorted in terms of the measures that have been taken or were taken by states, and the control order is one of them. So you have a whole variety of mechanisms that states have started to employ in order to act against terrorism in the world. And certainly, the human rights that we normally would sort of hold dear and would like to see enforced and implemented in matters of this nature have been sort of eroded over time. And there are court cases going on in European, under the European Convention on Human Rights and in the European Court of Justice, for instance, where effect has been given to Security Council resolutions in a manner that was undermining of human rights principles. So this is indeed an ongoing debate and a serious problem in many states of the world.
Well, I must say, I'm very happy to hear that you say that there is attempted or actual intervention by these scholars of the world, because, I mean, as an international law professor, somebody who is learned in the field of international, has done extensive research, you hear or see stories of this nature. For example, Cerie Bullivant, our Skype guest. I mean, how does that kind of play around in your mind? What feelings do you kind of have relating to that? And I mean, is there a way that this can be fixed?
Well, it makes you alert to the fact that we should never be complacent about the rights that we have. It can be sort of eroded at any time, depending on circumstances, depending on governments, how they see things and how they want to react to certain threats, etc. And that there should be constant vigilance. I think in any state in where you have pressure groups, they must sort of, inform the public about it, and there must be a national and an international debate on this. Unfortunately, there is a lively debate the world over on this issue. It's not a fact that people ignore it, and it's actively discussed, and there's grave concern about the effects of the anti-terrorism measures that were taken since September 11.
So, listening to Brother Cerie Bullivant, I mean, let's look at South Africa now, for example. We have what is called constitutional sovereignty, right? So we know that the constitutional law it takes precedence over any other law, and any other law that is in conflict with the Constitution is invalid. Right.
Correct.
So let's look at the control order, for example. Now, I come to you and I say to you, for the next 2 years, for no reason, or at least any reason that we're giving to you, you will report at this police station, and you know what, just for safety's sake, we're going to take your passport away. That is a direct conflict with the right to freedom of movement, for example. Then there's the one of disclosure. We're not going to tell you exactly what evidence we have against you, but we're going to still hold you to this order. Would something like that work in South Africa?
Well, it depends on the severity of it, and I think one of the important issues to consider is the following. When something like that happens, the question is, do you have remedies in your national legal system to fight that and to oppose it?
Very interesting.
As long as you have functional courts and you have functional remedies and effective remedies, then at least you have the mechanism to challenge those mechanisms that governments decide on. The real problem lies when you are in a country or in a region when those sort of remedies are not available.
So the UK, Cerie, you've heard what the professor said about remedies at a national level. I mean, do you know of any remedies that the UK law has to counter a situation like the one that you found yourself in? I mean, the judge said, had he heard of this order in the first instance, he would have quashed it immediately. How come it didn't get to court so quickly?
the problem is that for one of these orders to be placed on somebody, it's not a measure that's taken by the security services or by the police. It's something that's done through the executive. So it's a power of the government to take away your liberties. So, and in at least the first stages, the judicial oversight is only that there isn't a glaring mistake in the order. And by that they mean that, look, it says here that you should be putting this order on Cerie Bullivant, and this guy's name is David Johnson. But beyond that, in the first instances, judges aren't asked to review or look over the information. Now, the problem that this means is that you can be put on this at the behest of the Home Secretary, and then you're then stuck in a legal limbo until you can get to a High Court hearing at the final junction. That process takes at least 2 years. And even with the rebranded systems of TPIMs and other systems that the British courts have brought in, the wheels of justice turn very slowly. So you're always limited in how much recourse you have. And the fact of the matter is that by the time you get to a stage where you can clear your name, in whatever form that is, you've already been punished without having committed any crime.
For a sufficient period of time. So, Professor, that would be one of those lacks of national legislature to counter a problem.
Yeah, that deals exactly, this is a very good example of the effectiveness of a remedy. Yeah. You can have lots of remedies, but the question is always, are they effective? Yes. There's another important point that the gentleman has made, and that is about the role of the executive. And I know that it has happened, and it's probably happening in many countries, that more power is given to the executive, and at the same time, the review powers of the courts over executive decision-making is sort of limited.
Or non-existent sometimes.
And we had the same situation under the previous government.
So when you say executive, so just explain to our viewers who we're talking about.
That's where your cabinet makes the decision, or it's the minister or whatever, okay. An executive figure in government is given the power to take certain decisions. And sometimes what goes hand in hand with that is the fact that the powers of the courts are limited to review those decisions taken by the executive. And that is one of the worrisome developments that we have in certain parts of the world. And it reminds us of what happened in this country prior to 1994, where certain powers were given to the executive and with the exclusion of the courts to review the decision-making by the executive. And that is a very problematic situation.
That's how we ended up in the situation we ended up in.
I think, generally speaking, any situation where politicians are given powers to restrain the liberties of individual free citizens, and that sort of power to take away liberty is taken out of the judiciary, is a problem. Politicians are always politically motivated, whereas an independent judiciary, an independent police force should be acting, in theory, in accordance with protecting the people of the country. And generally speaking, any time that you have power to remove liberty going to the executive, it's a move in the wrong direction. In Britain, the basic legal principles for this come from the Magna Carta, which sort of outlines that no free man shall have his liberty removed without a due process and a trial by his peers. And we feel at Cage that these basic principles that have been in existence for hundreds of years are being undermined by measures such as control orders, TPIM, SIAC, and other such measures.
That's, I mean, it's really something that, you know, food for thought. Yeah. Professor, I want you to just lull over that for a quick second. I'm going to just advise the viewers that, as we were obviously very well know, and as I discussed with you, this is an interactive show. We encourage callers to phone in. After the small ad break that we'll be taking in a few seconds, I would like the callers to call in and pose any questions to the professor and to our Skype guest. The number to dial is 011 086 7701 or 2 or 3. Again, the number 011 086 7701 or 2 or 3. Obviously, it appears at the bottom of your screen. Also, for further information on Cage UK, their email address is www.cageprisoners.com or cageuk.com. So if you want to get more information,
sorry, it's cageuk.org.
Sorry, at cageuk.org. Thank you, Kerry. So after this ad break that we'll be taking in a few seconds, then please call in and do that. So, Professor, we'd like to obviously let the viewers interact with us a little bit and just get a feel of what it is they're trying to understand about this international law. As I mentioned to you, we've been doing this quite a bit. We've talked about international law, we've talked about human rights, we've talked about certain political situations along the road, which ultimately all affect us in some way or another. So it's important for our guests and our viewers, at least for our viewers and listeners, to tune in and to ask the questions that they want. We'll be coming back to you very shortly. Assalamu alaikum, and thank you for staying with us. Assalamu alaikum rahmatullah, and thank you very much again for coming back to us. We are Legal Ease, the show that converts legal jargon into legal ease. If you've just joined us, we're sitting with Professor Hennie Strydom, International Law Professor and NRF Chair on International Law, situated at UJ, and also via Skype, we're joined by Cerie Bullivant, a previous sufferer of control order, which is something that these international countries are utilizing to try and control or suppress what they believe to be terrorism. We'd also like to remind you that the phone lines are open and this is an interactive show. The number to dial is 011 086 7701 or 2 or 3. Professor, we listened just now to what Cerie Bullivant said. What of that was relevance to us insofar as international law is concerned?
Well, the one point which should be stressed all the time is the requirements of the rule of law. The rule of law is there to prevent arbitrary decision making. And that is the latest point, I think, that he brought out quite clearly. And the moment you have sort of arbitrary decision making within the executive or any other place in government, you're undermining the rule of law and you bring uncertainty into the legal situation. And you also bring uncertainty into the legal aspirations and the legal rights of citizens of that country. And I think in many instances where the executive has been given too much power to make decisions in this regard, there's always the danger of arbitrary decision making. And that is one of the sort of major concerns, I think, that one constantly hears about and reads about.
What about the effectiveness of an act such as a control order or the Anti-Terrorism Act? And can we just elaborate a little bit on what that is? Is that a bilateral agreement between the United Kingdom and the United States, or is that an actual piece of legislature ratified by the UN now?
No, it's a pure piece of national legislation passed by a country's parliament.
Okay, so it's internal.
It's internal. It operates at the domestic level, and it's there to give certain powers to the police, investigative powers, and to regulate the government response to terrorism, etc., and to put the measures that the state is supposed to take into a legal and legislative framework. All the other dealings that are going on between different countries in assisting one another, that will take place in terms of all kinds of agreements between them. But that's something separate from the law.
That's kind of the assistance, which is dangerous in its own right. Cerie, we were chatting just now before the ad break. We were talking about the stretch of this Anti-Terrorism Act and how far really the national legislature, or at least the country that's enforcing it, is taking it. What has been your experience in the UK of this Anti-Terrorism Act, and how far is it stretching?
Well, this is one of the things that's most terrifying about the anti-terror legislation. It's the complete range of how far it goes now. For example, something we'll be talking about later is the arrest of Moazzam. But there's also instances of journalists, of lawyers, people who clearly have no links with terrorism as most people would envisage it, as in acts of terror within the UK to attack civilians. But they're being caught up in these wide-ranging powers, and largely now the Terrorism Act is being used not just to protect the public, but to silence dissent. And that's a very
scary,
worrying step.
I mean, it's almost dictatorial in nature.
Yeah, that was especially in the early days after September 11, when states started to react to the threats and to comply with Security Council resolutions and with treaties. This danger was sort of mentioned quite clearly, that governments may use their powers to get to the opposition. And the reason for that, or alerting the sort of world to that danger, is purely because of the fact we do not have a uniform definition of terrorism in the world, in terms of a treaty or in terms of anything else of that kind.
So how do you decide, really?
So
That's the question,
you have different approaches amongst the different states of the world in terms of their national legislation, how they define it and what they will consider to be a terrorist act or a terrorist activity. And there's no uniformity in that regard. And that's why the measures in reacting to that also differ from country to country.
Well, Cerie, yes, go for it.
Would you mind if I interject and ask your guest a question?
Please, Cerie, do so.
But from sort of international law perspective, would what the rebels are doing in Syria be considered terrorism, i.e. fighting against Assad and the regime of torture and massacre that he's been presiding over? And also from an international perspective, foreigners joining that the rebel forces, is that necessarily a clear-cut issue within international law, or is there a lot of grey there?
In terms of the kind of conflict we're having in Syria, it is a typical internal armed conflict. And the rebel movements fighting the government forces will be considered as combatants in terms of the Geneva Conventions, provided that they comply with certain conditions or requirements. They must carry their arms openly, they must have some kind of a uniform, and they must conduct their hostilities in terms of the laws of war. I do not know whether there are sort of other groups besides the rebel groups which might fit the definition of a terrorist movement. But purely looking at the conflict and the kind of forces fighting one another, it's an internal armed conflict, and those forces are considered to be combatants in terms of international humanitarian law. But that does not exclude the fact that there might be other groups exploiting the situation for other reasons. And the facts on that, I do not have a sort of factual basis to make a clear-cut assessment at this point in time.
And with the issue of foreigners joining an irregular rebel army, would that automatically put them into terrorism legislation, internationally speaking, with regards to the Geneva Convention?
No, because we do not have that kind of definition at that level to make it easy for us to categorize them as such. They can join on either side. The only problematic issue might be where they join as mercenaries, because mercenaries do not enjoy the protection of the Geneva Conventions, and in some instances in national law, in terms of national law, they might be outlawed. So I do not know under what conditions they join, whether it's voluntary and whether they fight as normal rebels or as normal soldiers without gaining extra remuneration for the services that they deliver. That is a factual question. And only if you have the sort of factual basis established, then you can properly categorize the different groups.
So even then, so basically, Cerie, what the professor is saying ultimately is that it's so difficult really to identify whether or not an individual is protected in accordance with the convention, one, and if not, then is he in contravention of that convention? And then only will you be able to determine whether or not this Anti-Terrorism Act can be applied to.
Yeah, I can also say that we had the same sort of difficulty in categorizing detainees and arrested persons in the Afghan war after 9/11, because of the sort of fluidity of the situation. Some people were part of Al-Qaeda forces and others were part of the Taliban, and others were sort of in between.
Yes.
And that's why we have the debate about the categories of people detained in Guantanamo Bay.
Absolutely.
Some are clearly combatants and are entitled to prisoner of war status. Others might not be. But I mean, the whole issue has been muddled because of the response by the United States government on the treatment of those people in Guantanamo Bay. And that is also a matter that ended up before the courts in the United States, and which is still today a constant debate in the world.
And unsettled, really speaking. And you know, I'm glad you brought it up. And Cerie, you'll confirm this, that out of the 800 people that have passed through Guantanamo Bay, Professor, and this is where we come to the application of these laws, 800 people who've passed through Guantanamo Bay, it's no secret that every single one of those people were Muslim. Now, when they talk of this anti-terrorism, war on terror, one will ask, really, are they really talking about this war on Islam? And I mean, is that something that legal jurists or legal minds are looking at, or is that just
I think that's purely a question of application. The law must be applied equally
and consistently.
And consistent. That's one of the basic principles in any rule of law state, and where you have a proper functioning legal system.
Yes.
The moment you start sort of selecting, and I'm not saying this is the case here, I'm just arguing. The moment you start selecting a certain group of people and apply it only to them in an unfair or discriminatory manner, then of course you are violating that basic principle of equal application.
On that point of equal application, it's very, very interesting in a UK context that of control orders, of TPIMs and of SIAC, actually SIAC being the only exception, every single person who's been gone through these measures has been a Muslim, and that is despite the fact that there is still a threat in Northern Ireland and to an extent on the British mainland from Irish terrorism, from Irish republicanism, which actually has carried out far more attacks during the period from 9/11 until now on the British mainland than the so-called Islamic terrorists. But yet the Irish terrorists aren't treated in the same way. In fact, the only non-Muslim person to go through the SIAC courts was a Russian spy who was deported through those measures.
When you say SIAC, what is SIAC?
So the SIAC is a Special Immigration Appeals Committee, which basically allows, through secret evidence, non-British nationals to be deported to any country. And often this includes countries where it's known that they're going to be tortured.
It's unbelievable. Let's look at the reason why we came here. Cerie, Moazzam Beg, a fellow member of Cage UK, and also a previous guest, a former guest of this show, and someone who we really liked listening to and liked talking to on the show, and was very inspirational and informative on this whole issue of Guantanamo Bay. He was a member of Guantanamo Bay, an inmate of Guantanamo Bay for a substantial period of time. I think it was 4 years. Was then released without charge and ultimately ended up instituting action against the British government and being successful in their complicit conduct insofar as his rendition was concerned, and that's what it was called. He's now been arrested again. He was arrested on the 25th of February. Take us through what happened and the circumstances of his arrest, if you can.
Well, from my perspective, I was actually, I live very close to Moazzam in Birmingham. The Cage office is in London. I was on my way down to London on a coach when I found out that he'd been arrested. And for us at the Cage, it was a complete shock. We're like a family. We're all very, very close. And if I can put it like this, if Cage family, and Moazzam is the father. He has been through the primary purpose for which this group was set up, which was initially to do with Guantanamo Bay. Our remit has expanded as the war on terror has expanded as well. But initially, this was caged prisoners was born out of a reaction to Guantanamo Bay. And Moazzam has been one of our firmest and staunchest defenders and advocates since his release. And for him to be taken like that was initially a great shock. And when we realized what he was being accused of, that shock very quickly turned to outrage. Anybody that has met Moazzam knows that he is a gentle soul who stands and speaks for justice. And despite what he went through at Guantanamo Bay, you never hear bitterness or hate from him about that time. He's philosophical about it. He understands that there's a debate he had around it, and he channels what happened to him towards calling for justice.
So what was
I urge anyone who is inclined to read an article by Craig Murray. You can Google it on Moazzam Beg. Craig Murray is an ex-British ambassador who wrote a very moving piece about the character of Moazzam.
So, Cerie, just explain to us then, you said you found out the reason why he was arrested. Could you explain that to us? Why was he arrested? What was the reason, the justification?
The legislation that was used was the 2005 Terror Act, Section 41. In layman's terms, what this is acts of preparation or instigation of terrorism. The police later gave further evidence they believed Moazzam had been involved in terrorist training camps in Syria. Now, this is such a ridiculous claim that if it wasn't so serious, if it wasn't so painful what was happening to him, it would be laughable. Moazzam's last trip to Syria was in 2012. Before going to Syria in 2012, he had meetings with the security services, the police and MI5, who both had their lawyers present. He had his lawyers present. He laid out exactly why he was going there, what his intentions were, and they allowed him to go, and they allowed him to return as well. While he was there, he was blogging the entire time about the work that he was doing in Syria. There are videos up on YouTube of what he was doing in Syria. So he has been completely open about his intentions, his objectives, and what he was doing there for the whole time. And yet the government have still, in 2014, remember, he went there in 2012, in 2014, have used these historical incidents that he was open about as some sort of claim that he was involved in terrorism. When he came back from South Africa in December, they took away his passport, and now they've arrested him.
So you said further evidence. I mean, was that made transparent to you? Did they disclose this evidence, or did they just come out and say, when inquired, and I'm assuming you had to inquire first, that, well, he's arrested in terms of the Section 41, and yes, we believe that he's been preparing or instigating terrorist acts in Syria. Is that what they said, simply as that, or was there any formal documentation?
Well, we are obviously in touch with his solicitors, so and we're working very, very closely with them to try and ensure that, firstly, he gets all of the rights that he's due, and that secondly, that we can best campaign for his release. We believe that his arrest is a politically motivated arrest, that there is no evidence of his wrongdoing, and that it is very, very important that this is seen within the context of terrorism legislation being used to silence dissent. Moazzam, while he was in Syria, uncovered evidence, and we've written about this and exposed it on many occasions, of British complicity in rendition and torture. Yeah. And we feel that it's no coincidence that a couple of days before we were due to release a very hard-hitting and powerful report on Syria, our director of outreach, a major figure within the organisation, is arrested under terrorism, which not only maligns his name and his credibility, and bringing up many old accusations that had already been put to bed for many years, but also then maligns the organisation of Cage.
So Cerie, where is he being detained currently? Where is he being held?
He's being held in a police station in the West Midlands at the moment. Moazzam, thanks be to God, is a strong man, and he is not going to be broken by this. He went through Guantanamo Bay, and as well as the West Midlands police are trained, I don't think their interrogation stands up to that of the CIA.
Scary though, and let's listen to Professor Strydom. Sorry, Professor. So you know what's coming out there is they kind of you can hear there's almost an acceptance in a sense. Is that really how we've got to look at the situation? That we kind of have to accept that anti-terrorism laws exist. They can do pretty much what they want. They can tell you pretty much what they want, and there's nothing that we can do about it. Is that really how it is? Or in this situation, what can be done for Moazzam Beg?
This is not the way it should happen. If that is in fact what lies behind the whole story. I think the main issue that we should consider here is the following, irrespective of where it happens, is that where an arrest and detention takes place, for whatever reason, that there should be some kind of a basis for that.
Right.
A reasonable suspicion or a reasonable view of or reason that information could be gathered or that a crime has been committed. So that is the normal way in which the law operates. And the moment you start chipping away at those kinds of well-established and proven principles, then you move into all kinds of grey areas. And I'm sure that these kinds of incidents happen in many places of the world. And once again, it reminds us about how vigilant we should be about the laws that we pass and what we want to achieve, how they are implemented especially, and what effects they have on society and on individuals and on your legal system. Because eventually, one of the crucial issues that you sit with and the questions that you have to ask for yourself is, what does it do to the integrity of your legal system?
On that point of the integrity of the legal system, I have a quote that I imagine you guys, where you are, will be more familiar with than us here in the UK. I was made by the law a criminal, not because of what I had done, but because of what I stood for. And that's a quote which is circulating widely in regards to Moazzam, but as I'm sure you and your viewers will remember, was originally from Mandela, God rest his soul. And I think that for us at Cage, this is very much how we see what's happening to Moazzam, that he has been arrested not for a crime, because as we'd already discussed earlier on in the show, even the thing that it's alleged that he may have done is on very, very shaky ground as to whether that would even be considered terrorism, even if he had done it. But it's not even a criminal, necessarily even a criminal act, even if he had done it. And if he has, and he's been very, very clear about what he was doing in Syria anyway during that time.
So Cerie, let's look now at what are his lawyers actually doing. I mean, and Professor, is it a situation where they take the act, they'd scrutinize it, and they'd look for loopholes in the application of it against Moazzam Beg? Is that what they're doing, and is that what they should do?
Well, I suppose that there are sort of basic principles well in place in the UK legal system against which the action and the implementation of the act will be tested. And I'm sure that there are able lawyers taking on this case, and that they will look at every nook and cranny and then decide on what is the best strategy to follow in this regard.
Is that what's been happening, Cerie?
Well, Moazzam is very fortunate. The solicitors that are handling his case are internationally very well known. Gareth Peirce is considered by a great many people to be a legal genius in regards to how her defense and the cases that she's worked on and her profile. And the situation that Moazzam finds himself in at the moment is that he is without charge and he can be detained for up to 14 days without charge. But Gareth is working obviously to secure his release and to secure his rights.
And how is it looking so far? What is the status of their applications? Or
at the moment, the judge has extended the period that he can be held until Tuesday. So other than that, at the moment, there's a period of ongoing investigation and ongoing interrogation of Moazzam. But beyond that, it's quite hard to go into too much legal detail without potentially jeopardizing the ongoing investigation.
Of course. Professor, it sounds promising, and I say this because he mentioned that there has been a judge that's looked at this matter. So earlier we talked about the fact that the judiciary's powers were limited insofar as review is concerned of actions that came out of the Anti-Terrorism Act. So that's quite promising, I think.
It is promising, but there's also another legal avenue. If, for instance, there's no success with the internal remedies available, or the outcome is negative, there's still the European Court of Human Rights, where matters of this nature can be heard. And I'm sure that the lawyers are sort of at this point in time contemplating all options available to them, and that they will certainly pursue what is possible within the legal system and what is to their avail at this point in time.
Okay, there you had some very free legal advice, very valuable legal advice from a very esteemed professor. So I'm assuming, though, obviously having regard to the solicitor that is working on Moazzam's case, they probably would have already done this or would be looking to do this in the event that they're unsuccessful next week, Tuesday.
Well, I think we can be sure, no matter what the outcome is on Tuesday, that his legal team are very experienced. Gareth has won many very, very high-profile cases, and I mean, she's even been portrayed in an Oscar-winning film by the very famous actress Emma Thompson, because of the scope of the cases that she's worked on. And I think that it's good to know that Moazzam's in safe hands in regards to his legal team. It's also worth noting that in cases like this, British judges in the lower courts are very, very conservative in going against the government on big cases like this. So, for example, generally speaking, until you get to the higher courts and eventually the Supreme Court and possibly even the European courts, you're not going to find many cases where the judges will rule against the government position in the lower courts. A perfect example of this was David Miranda, who is a journalist who was held under the terrorism laws for his work exposing the NSA's spying program. He's had his first court hearing in the lowest court, and the judges ruled against him on that. And generally speaking, in the British system, we expect this in the lower courts. It's very, very rare for the lower courts to go against the government. It's only until you get to the higher courts that there's really a prospect of justice.
So what is, and very quickly if you can help me here because we're almost running out of time, but what is the prospect of him actually then being taken to Guantanamo Bay? Is that a possibility?
No, I don't think there's any possibility of that. Sort of the future for Moazzam kind of holds branching paths. At the first branch, he will hit within the next 10 days. He'll either be charged or released pending further investigation. If he's charged, the next question will be whether he receives bail and is released back into the public, or whether he is held on remand in prison, awaiting some sort of further decision to go to trial. So everything is kind of up in the air at the moment.
Okay. Professor, so we've almost come to the end of our show. I mean, we've listened to the story of Moazzam Beg, quite different, I must say, to how it was when he was renditioned. And it seems like there's some prospects. And what's interesting there is that, as you mentioned earlier, that there's an enforcement of national legislation. And hopefully we'll hear an outcome coming soon that he will be released and the charges will be dropped. Thank you very much, Professor, for your help, your assistance this evening, your professional wisdom. It's really, really encouraging. And I'm sure a lot of you are sitting at home who are lawyers and so far will look to one day do international law and perhaps maybe even their LLM. We say thank you also to Cerie Bullivant. Jazakumullah khairan to everybody for watching. Thank you very much and join us again next week on Legal Ease.
Thank you for having me on the show.